Section 6A of the IG Act authorizes inspectors general to access, quote unquote, all records belonging to their respective agencies. But 2 weeks ago, the Justice Department's Office of Legal Counsel issued a legal opinion claiming that that word all does not actually mean all. Today, we will examine how this opinion is hindering the work of the Justice Department's inspectors general and threaten all inspectors general. The IG Act means what it says. The Department of Justice IG is legally entitled to all department records, period. If Inspector General deems a document relative to his job, then the agency should turn it over immediately without hesitation or review. According to the Department of Justice Inspector General, the department did exactly that prior to 2010. However, in 2010, the Federal Bureau of Investigation suddenly changed that practice.
The problem of our access to information is a relatively new one. Prior to 2010, neither the Justice Department nor the FBI questioned our legal authority to access all documents in its possession, and we obtained grand jury wiretap and credit information without legal objection and without the need for a legal opinion. Indeed, it would be hard to imagine how we could conduct effective oversight of the FBI, the DEA, and other law enforcement components if we were prohibited from reviewing information like grand jury and wiretap information that those agencies frequently use. The OIG always handles such information with great care, and we fully and completely comply with all statutes limiting the use and disclosure of such information. Indeed, we have been provided with access to some of the U.S. government's most sensitive information in order to conduct our oversight, and there has not been a single occasion in our 27-year history where we have been accused of mishandling such information. However, in 2010, FBI lawyers concluded that our office could not have legal access to such information despite its past practice and despite the fact that no laws had changed. FBI lawyers also identified 10 other categories of records where they believed we might not be entitled to access. Since that time, our office has faced numerous challenges to our access to department records, seriously impacting our ability to conduct oversight. In May 2014, Deputy Attorney General Cole asked the Office of Legal Counsel for an opinion addressing the FBI's legal objections to our access to grand jury, wiretap, and credit information. The OLC issued its opinion 2 weeks ago and concluded the following. First, the Inspector General Act does not entitle our office to access grand jury, wiretap, and credit information. Second, our office can only obtain such records if the disclosure exceptions listed in the grand jury, wiretap, and credit laws permit Inspector General access. Third, in every instance, the decision whether these disclosure exceptions apply will be made by department employees, not by the OIG staff. Finally, as the department itself acknowledges, there are circumstances where disclosure to the OIG would not be permitted. The legal underpinning of the OLC opinion represents a serious threat to not only my independence, but to that of all inspectors general. A hallmark of the IG Act that inspectors general are entitled to independent access to all information in an agency's possession has been pierced. For the first time since the IG Act was passed in 1978, the word all in Section 6A of the IG Act no longer means all. And placing agency staff in the position of deciding whether to grant an inspector general access to information turns the principle of independent oversight that's enshrined in the Inspector General Act on its head.
An IG office must have unrestricted view of the agency that it oversees. I would argue it is those documents an agency hesitates to provide an IG for review that may be the most important for the IG to have. The very purpose of having an independent IG is undermined if the office has to seek the agency's permission in order to carry out its mission. Agency actions that restrict an IG office's access to records in turn, limit Congress and the public's ability to oversee the executive branch and hold it accountable. Chairman Grassley and other congressional leaders on both sides of the aisle have rightly condemned the OLC's opinion. We've been hearing it through the first panel. IGs cannot possibly be effective watchdogs if they are forced to negotiate with the very target of their investigation for access to their records. In comments to POGO, Professor Charles Tiefer, a former Deputy General Counsel of the House of Representatives, said the OLC opinion treats DOJ as if it were, quote, above the law. DOJ can now use, as he described, the Midas touch approach to turning material secret. Obviously, Congress should clarify that all means all, as we've been hearing repeatedly. The DOJ IG should also be given the explicit authority to investigate allegations of misconduct throughout that agency, including allegations of prosecutorial misconduct committed by DOJ attorneys.